Welcome to this Learning Together video on HM Revenue and Customs, HMRC's reviews and appeals process. On the 1st of April 2009, HMRC changed the way tax disputes and appeals are handled and introduced a more consistent approach to their internal reviews. At the same time, the existing tax tribunals, including the General and Special Commissioners and the VAT and Duties Tribunals, were replaced by the first tier and upper tribunals. In this session, we'll look at what happens when customers disagree with appealable decisions, what steps they should take, and how HMRC deals with them within the reviews and appeals process. We'll also look at how HMRC decision makers should deal with disputes in line with HMRC's litigation and settlement strategy, LSS, the work of review officers and when they will liaise with you as agents on reviews or appeals, and customers' rights if they disagree with a decision of the tribunal. The decision maker. The HMRC officer who's responsible for making the decision is called the decision maker. A decision can include an assessment notice, closure notice, or a letter setting out HMRC's final position. When HMRC makes a decision that can be appealed against, they will always tell their customers what their rights are. Before issuing a decision, the decision maker will have considered all the facts and will be able to provide evidence to support the decision they've made. When the decision maker notifies a customer about a decision, the notice must explain the appeals and internal review process. In most cases, the decision notice or a separate explanation letter will tell the customer what HMRC's decision is, what HMRC believes are the relevant facts, the reasons for the decision, the legislation and, if relevant, case law supporting that decision, where appropriate, the amount of tax and/or penalties that HMRC believes are due. In addition, the decision notice will tell the customer that they should contact HMRC if they don't agree with the assessment or other decision. It will also tell the customer about their appeal rights and the time limits that apply, what will happen if HMRC doesn't hear from them within the time limit, and for indirect tax, that they can ask for a review of the decision. Disputes. The majority of discussions HMRC has with their customers won't lead to disputes. HMRC will work with the customer to either establish the correct legal interpretation of agreed facts or to determine the facts that are relevant to their tax liabilities. This dialogue is the normal basis for discussion between HMRC, its customers, and their agents. On some occasions, it will become apparent that there's a substantial and material difference of opinion that won't be easily resolved, and some form of formal dispute resolution will be required. LSS. I'm sure that all of us seek to avoid issues escalating to the status of a dispute, but with the best will in the world, sometimes we don't agree. HMRC's LSS sets out the principles within which they handle all disputes about any tax, duties or credits. The LSS underpins all of HMRC's interactions with their customers and agents involving potential disputes. The prime focus of the LSS is to avoid getting into disputes and to seek non-confrontational solutions where possible. This strategy aims to use the law to make sure the correct amount of tax and duties are paid at the correct time, while treating all of HMRC's customers in a professional, fair and even-handed way. The two key elements of HMRC's approach to tax disputes are supporting customers to get their tax right first time, preventing a dispute arising in the first place, resolving those disputes which do arise in a way that establishes the right tax due at the least cost to HMRC and its customers. In most cases, this will involve working collaboratively. So what would you recommend if you and your client find yourselves at an impasse in a particular case? It may be necessary to take a step back to clarify the nature of the dispute. Is it essentially about either disputed facts or the application of law to particular facts? Once you're clear about the nature of the dispute, decide what you think the right answer or most appropriate action is and what you want by way of resolution. It's important to ask these questions because they will inform a decision about how best to resolve a dispute. And being clear about what you want will help the chosen process work most effectively. What are the options? For direct tax, where the customer disagrees with an appealable decision, they must appeal to HMRC in writing within 30 days. After the customer has appealed to HMRC, they may either discuss the matter with the decision maker in an effort to settle the appeal, ask for a review, or notify their appeal to the tribunal. If the customer asks for a review, they may not notify an appeal to the tribunal during the review period, but they can notify their appeal to the tribunal after the review is finished if they're unhappy with the outcome. For indirect tax, where a decision is notified, the customer will be offered a review. The customer may then either accept the decision, send new information or arguments to the decision maker, accept HMRC's offer of a review, or appeal to the tribunal. If they don't accept the decision, they have 30 days to either contact HMRC or appeal to the tribunal. Once the customer has been informed of the review conclusion, they can either accept it or notify their appeal to the tribunal. HMRC is currently exploring an alternative means of resolving disputes, the Alternative Dispute Resolution, ADR. ADR has been successfully piloted in the largest businesses, and HMRC is exploring the extent to which the use of ADR techniques might be helpful when dealing with small and medium-sized businesses. The review officer. The review must be a genuine second look at the case, and it's therefore important that review officers are not linked to the decision makers, for example, by being their managers. For most cases, reviews are carried out by review and appeals teams, geographically separate from caseworkers and within a different management chain. This will benefit both customers and HMRC. Customers will benefit by being reassured that review arrangements are fair and transparent. HMRC will benefit because they will only maintain decisions that have a sound legal basis and are in accordance with HMRC's LSS. In order to help maintain a detached approach, review officers should discuss cases with decision makers only as far as it's needed to clarify a particular point or issue. Likewise, the review officer should properly understand the customer's position and offer equivalent telephone or face-to-face contact to the customer and agent as necessary. Review officers will review the decision in question, and in doing so will review all relevant correspondence and other material to make sure the decision is well-founded. On concluding a review, the review officer may decide the decision under review should be either upheld, varied, or cancelled. Review officers don't have any additional powers to those available to decision makers, but will be able to overturn decisions and vary them under the normal statutory rules. It's not the review officer's role to carry out casework as such, but rather to review the work that's already been done. A review officer's role when reviewing a case is to make sure a decision has been properly made, is legally correct in HMRC's view, and is one which HMRC would want to defend at tribunal in accordance with the LSS. For example, if the case was subject to extensive internal checking before a decision was made, the review officer isn't expected to challenge any technical advice unless there's a reason to do so. Examples of extensive checking may include 2 or more layers of informal review separate from the decision maker, and possible input from specialist technical advisors or counsel. Instead, they should confirm that all appropriate procedures were followed and that the decision reflects the approved process. Of course, they're expected to look at the technical advice and use their judgment to decide whether there's any reason to question it. The important principle to remember is that the role of the review officer is to review the decision made by the decision maker and to decide if it's defensible. The customer should be able to see that the review was thorough, impartial, and took full account of their arguments. They should also understand from the review conclusion letter the case that HMRC would be likely to put forward if the case proceeded to tribunal. How customers and their agents can prepare for a review. Reviews are carried out by members of staff who are not involved in the original decision. For most cases, reviews are carried out by review and appeals teams, geographically separate from caseworkers and within a different management chain. The review officer's role is to take a fresh look at the decision, to consider whether it's right and whether it's in line with the LSS. HMRC will need the following key information from you when you're asking for a review. Details of the decision or assessment you disagree with, an explanation of what you disagree with and why, what you think are the correct figures and how you've calculated them, or the correct legal analysis where applicable. When preparing this information, it's important to remember that this is a fresh chance to make your case. If you don't set out your case in line with the best practice, the review officer may have to write to you again and may struggle to understand your position. At the very least, this may add delay. You have a legal right to make representations to the review officer, and making your case clear and understandable will help make sure there's an effective review of the case. When a customer or their agent requests or accepts a review offered by HMRC, they should make the review officer aware of all the relevant facts, evidence and arguments. Some agents have told HMRC that they find it helpful to think of the review as a less formal tribunal. The review officer will consider the evidence used by the decision maker and any other evidence provided by the customer or their agent. Evidence is documentation or other factual material, including oral evidence, that the decision maker or agent rely on or consider relevant to the correct analysis of their case. Review process. If the customer accepts the offer of a review, the case papers must be sent immediately to the review team. The review must normally be carried out within 45 days of HMRC receiving the request, but may be extended with the customer's agreement. The review conclusions will be notified to the customer and the decision maker. When a review officer is allocated a case for review, they'll tell the customer that they are responsible for carrying out the review and give their contact details. Sometimes customers may want to contact the review officer to put forward their side of the case. HMRC is statutorily required to consider such representations. There are strict time limits built into the review process. Cases are carefully monitored and controlled by the decision maker and the review officer to ensure that the review officer has sufficient time within the review period to fully consider all the facts. This is especially important if specialist advice, for example on a point of law, is being sought. On conclusion of the review officer must write to the customer setting out their conclusion and their reasoning. Customers have a statutory right to both be notified of the review conclusion and have an explanation of the reasons for the decision. Right to appeal to tribunal. Departmental reviews are not a compulsory part of the appeals process. Customers with the right of appeal can take their case to the tribunal, whether or not HMRC has carried out a review, but not while the review is in progress. This tribunal may be at a face-to-face hearing or on the basis of papers submitted from the parties concerned. This depends on the type of decision being appealed. Time limit for notifying appeal to the tribunal. Once the customer has been informed of the review conclusion, whether the review followed an HMRC offer or the customer's request, they can either accept it or notify their appeal to tribunal. Any appeal must be sent to tribunal within 30 days of the date of the review conclusion letter. Tribunals. The tribunal has a two-tier structure. The first-tier tribunal. Tax appeals will be heard in most cases by the first-tier tribunal. The administrative centre of the first-tier tribunal is in Birmingham, but hearings take place at a range of centres throughout the UK. The tribunal will decide some cases on written submissions alone. Cases are heard by a tax expert judge and a member or members with legal or specialist knowledge. This depends on the nature of the case. The first-tier tribunal's jurisdiction is to apply statutory rules to the facts of the individual case. If either the customer or HMRC is dissatisfied with the decision of the first-tier tribunal on a point of law, they may be able to appeal to the upper tribunal. They will need permission from the tribunal to do this. The upper tribunal. The upper tribunal hear a very small number of complex cases without the case being heard by the first-tier tribunal in the first instance. The upper tribunal is administered in London where most cases are heard. If either the customer or HMRC is dissatisfied with the decision of the upper tribunal, they need the tribunal's permission to appeal to the relevant appellate court, Court of Appeal in Northern Ireland, or the Court of Session in Scotland. Appealing to the tribunal. Direct tax customers may notify their appeal to the tribunal at any time after sending their appeal to HMRC, unless they've accepted an offer of a review, or they've asked for a review and the decision maker has written to them with HMRC's view of the matter. They may still appeal to the tribunal if they aren't satisfied with the review decision. In indirect tax, HMRC must offer a review in writing at the time they issue the original decision to the customer. Customers who don't accept the decision have 30 days to either send new information or arguments to the decision maker, accept HMRC's offer of a review, or appeal to the tribunal. If the customer appeals to the tribunal service will write to the parties with a hearing date or a request for a statement of case. Thank you for watching this video.